Hi there, welcome to the Saturday edition of The Burning Question. The fact that you are watching news over the weekend shows how seriously you take what's happening around you and in the country. So let's have an hour of engaging news conversation. Tonight, I picked two stories with two sets of questions each that should concern us as citizens. Earlier in the day, a CBI court in Chandigarh acquitted all accused in the 2008 Justice Nirmal Yadav case. Yes, 17 years after the rupees 15 lakhs were discovered from the door of Justice Yadav's namesake and fellow judge Nirmal Kaur. Nobody knows who delivered the money. It was meant for whom? Was it a kickback? Was it money of corruption? We don't know. It is ironic that this development comes amid Justice Verma cash row. What are the lessons from the Justice Nirmal Yadav case that we can apply to the Justice Verma one? Is top judiciary so powerful as to be above law? The latest case had rekindled the NJAC debate. Does the verdict today buttress the pro-NJAC sentiment? That's our debate number one. Also, a university in Houston, Texas, United States, is running a course on Hinduism, which, among other things, calls the religion a recent one, not an ancient one. Imagine the most ancient faith gets those kind of interpretations. No problem. Back home in India, the Mohanlal starrer Malayalam flick L2 Empuran is being panned for using Gujarat riots of 2002 as a prop to push a certain narrative, certain agenda. Even as a section of the population in Nepal struggles to get back Hindu Rashtra it lost in 2008 to communists taken together, one can easily see a pattern of Hinduism as an easy target. Yet we do not see street protests, not violent protests, at least not with threats to kill. This, even as news cycle, is forever full of this Islamophobia narrative, both in India and abroad. Is one side overreacting? That's our second debate tonight at 9:30 p.m. Let's get you the headlines first. A special CBI court in Chandigarh today acquitted Justice Nirmal Yadav, booked for receiving rupees 15 lakhs cash while serving as a judge of the Punjab and Haryana High Court in 2008. At least 17 Maoists were killed in an encounter with the security forces in Chhattisgarh Sukma. Chief Minister Sai, Union Home Minister Amit Shah hailed the forces. The University of Houston defends its course after a student calls it out for Hinduphobia and clarifies that its terminology may lead to misunderstandings.
The first aircraft carrying 15 tons of relief material took off at around 3 a.m. this morning from Hindon Air Force Base. It reached Yangon at around 8 a.m. India time.
And India launches Operation Brahmas and C-17 aircrafts with 15 and more tons of relief aid to quake hit Myanmar. Total aid over 140 tons. And the clashes during pro-monarchy protests in Kathmandu, 2 killed, 45 injured, curfew now lifted. All right, friends, amid the furore over the recovery of charred cash stash from the residence of a sitting judge of the Delhi High Court and his transfer to his parent court in Uttar Pradesh, a special CBI court in Chandigarh acquitted Justice Nirmal Yadav and all other accused of all charges in the cash at the doorstep case of 2008. The case has raised, or the verdict has raised, fresh concerns over the perceived lack of checks and balances in the system, particularly when it comes to top judiciary and the failure to act on graft. Take a look at this report, and I come back on the other side with a panel of guests.
Amid the in-house probe into the cash burning case, a ruling in the 2008 cash at doorstep case has yet again showed up the loopholes in the judicial system. A special CBI court in Chandigarh today acquitted Justice Nirmal Yadav of all charges in the 2008 cash drop case. The widely reported case pertains to a bribe that was found allegedly for Justice Nirmal Yadav but was wrongly delivered at the doorstep of her namesake Justice Nirmal Kaur. Justice Kaur filed a police complaint in the matter after finding the alleged bribe package in the name of Justice Yadav. However, 17 years to the day and numerous hearings later, the Chandigarh court disposed of the case, finding not a scrap of evidence to hold Justice Yadav guilty as charged. At a time when graft in the upper judiciary is the biggest national talking point, the case has revealed the fault lines in the judicial system and inability to establish guilt. The ruling also comes amid concerns and dissent from within the legal fraternity against the decision of the Supreme Court Collegium to send back the cash scam judge to the Allahabad High Court. With the judicial system yet again failing to establish judicial graft, is an overhaul the only way forward?
All right, we have 24 minutes for this conversation. Joining me, Kishore Subramanian, political commentator and financial expert. Two changes. A, he's joining us from Bengaluru, not Chennai, and today he's joining as a citizen's voice, though he leans towards the right. Also, Anil Tiwari, president of the Allahabad High Court Bar Association. He's joining us live from Allahabad, from Prayagraj, I believe. And then I want to begin with Advocate Rakesh Tiku. He's ex-chairman of the Delhi Bar Council. And I want to begin with him because he's defending the top judiciary in the present instance. Mr. Tiku, 17 years for a case, 2 investigations, one by local agency and then by the CBI, and multiple iterations later. The prosecution fails to prove anything and everyone is allowed to go scot-free. I mean, 15 lakh rupees reached the residence of a judge, and we don't know who kept the money for whom after 17 years. What a waste of resources. More importantly, Mr. Tiku, how do you defend the manner in which the judiciary functions in this way?
Thank you very much. Let me make it very even clear. All along, media role has been essentially informative. You have a data, you have evidence, probe into it and place it to the public domain. Next stage comes, if a guilt is found prima facie, the concerned agency, could be CBI, police, etc., or in-house, they will investigate. Then comes third stage is a court. Today you are dealing and apprehending that the acquittal by the CBI court could be termed or perceived as a reflection. Now, is it so that in India, CBI, whenever they file the case, the success rate is not more than 10%? Forget the case of a High Court judge. A case of Arushi murder case, the High Court said X, the Supreme Court reversed it. Session judge says something, the High Court reversed it. So it's easy. In any hierarchical judicial system, you got to understand there are two views. The evidence on the record which is available or made available would determine. You cannot blame the judge just because he is trying a case of his ex-superior colleague that he would or she would be biased for acquittal. Please understand, sitting in the media, sitting outside, we may have our own perception.
Okay.
But a judge has to decide what is before him as evidence.
Okay.
You are right in a way, delay in investigation does impact the final verdict. There's no doubt about it.
I mean, the first lesson in the LLB class is justice delayed is justice denied, Mr. Tiku. But you are saying maybe it's a perception. No, it's not perception. The rupees 15 lakh that was delivered at the doorstep was not perception, it was reality. And you're sort of saying that process is also important and not what people see happening. Mr. Tiwari, You think the judiciary could have done better in this case, in the Justice Yadav case? Everyone has retired, even in the case of one accused passed away also, and we really don't know what happened.
Actually, the basic procedure which is provided under the criminal law with regard to the investigation, safeguards, so many safeguards laid down by the judgments. Delay normally occurs in criminal trial. Delay is inevitable on account of these technical reasons. And delay is the main cause which has resulted in this. Today the judgment has come, acquittal has been done. I have not seen the judgment on what points the judge was acquitted. But you see, if I invite your attention on the judgment which was on a 482 petition which was filed by Justice Nirmal Yadav in the court of Punjab and Chandigarh High Court, that judgment deals with every paper relating to this case. That judgment itself will demonstrate as to how the judicial authorities have functioned in granting sanction, as to how they delayed the file, as to what are the lacunas. The case was investigated and trial continued only on account of effort of CBI.
Yeah.
And case went to...
Some connectivity issue there, it seems, with Mr. Tiwari there, and I'll come to him. Okay, I think we got him back. Yes, continue, Mr. Tiwari.
Yes, actually, my my connection is not proper.
That's okay.
Therefore,
now you're fine.
Sometimes I'm not listening to you. Sometimes you are not listening to me. What I'm saying is the delay is the only reason. The delay is the only reason in justice delivery system which has denied justice to the public at large, number one. Number two, the procedure is so technical, and taking benefit of that procedure, Nirmal Yadav herself is responsible for causing delay. There is one judgment when the Supreme Court has directed that you are delaying it, then this trial is concluded. There is a judgment of the Supreme Court where direction was issued why you are filing so many applications at different forums. Then the trial started and trial came to an end. But the...
Okay, lost the line again. Kishore, the fact of the matter is people don't want to understand, or maybe they understand, but they don't want to harp so much on process and procedure. They want to know who put those 15 lakh rupees outside the residence of a judge. They want to know who kept those 5 crore, 15 crore or 55 crore rupees in the outhouse of Justice Verma. And we are not, I think people want to really hold people accountable, people in power accountable. There has to be accountability fixed, Kishore, and it seems not to be happening.
Yeah, so good evening to my panelists. Let me give you some couple of quick points. First of all, the point that Abhishek you mentioned about justice delayed is justice denied is absolutely true. Justice must not be delivered but perceived to be delivered also. It is very important. Let's take the classic case of 1984 Sikh massacre riot. After 30 years, 31 years, we get judgments, or not, sorry, 40 years we get judgment. This is the kind of perceived justice that comes in a country where 144 people are there and few crore cases are pending. So I understand procedural requirement. I understand courts work on evidence. I also understand the fact of the matter that one is innocent until proved guilty. But remember, there are certain things which needs to be fast tracked. For example, bureaucrats and judiciary have to be above law. Number one, how many times the gentleman who was a bar council member told us very clearly that the prosecution rate of CBI is 10%. That is pathetic, which means either there is vendetta politics going on or there is filing of cases going just for vengeance. So let's understand one thing very, very clearly. Point number one, we need justice which is fairly quick. I'm only being very conscious in using the term fairly quick because we have a large population. Point number two, we need to understand that the multiple application business that happens in the Indian judiciary should be, I am a victim to it. I have got a court order in a particular case without going into the merits of the case, where a corporate is just sitting on contempt of court because they are absolutely confident that nothing will happen to them. The third important point is that multiple appeals should have a limitation clause. We already have a piling and backlog of cases. Justice must be delivered quickly. And when it comes to critical positions like bureaucrat or judiciary, they have to be much above law. And these are graft cases. We need to be very, very clear, light-handedly dealing these things. And that too, sitting on them for 10 years, 20 years, absolutely unbelievable.
Yeah. All right. I think Mr. Tiwari is back with us now. And Mr. Tiwari, my question is, as learned lawyers say often, there is rape but no prosecutrix. Maybe there is a body but no murder. I mean, that seems to be the takeaway from this verdict today in Chandigarh by the CBI court, that we can't find anything. Everyone is acquitted. There is no evidence, despite the fact that there was money.
Basically, my viewpoint is something different. When a judge is under trial, then it is not the individual who is facing a trial. The entire faith is facing the trial. The institution is facing the trial. Therefore, there should be rigid procedure. But our procedure is so lenient, provides so many lacunas, that the genius lawyers, by using those lacunas, get the trial delayed. It is an inherent defect in our procedure. Here, my viewpoint is, when judge is under trial, then there should be a different procedure to protect the public faith and to give the justice to the delinquent judge. Here in this case of Nirmal Yadav herself filed several petitions at different stages, and ultimately Supreme Court in 2014 caught her and observed that you, look here, Justice Nirmal Yadav, you are delaying this trial.
Yeah.
Then the trial gets concluded now, today, by a judgment of acquittal.
Yeah.
My anxiety is for different procedure, correct procedure. The legislature has to fill up those lacunas.
Yeah.
Secondly, the most important point is, she was having a position of a judge, and the shield which protects the system, the shield is which protects the judge, gives them liberty, power, extraordinary power to influence the proceeding.
Yeah.
That is why the delay occurred.
Yeah.
And ultimately, she is acquitted.
Yeah,
she is acquitted despite this fact that there was evidence to this effect.
Yeah.
There was evidence to this effect that cash was delivered and was received by her at the later stage.
Right. I sort of agree with you, Mr. Tiwari, that there has to be a different process when it comes to judges, because, as they say,
Yes.
Caesar's wife.
My point is, because it is not trial of individual, it is trial of institution.
Absolutely. Absolutely. And that's why we are taking a position that maybe, just maybe, the lordships need to really have a hard look at their own systems. And of course, we are having this conversation in the midst of what has happened with Justice Verma. And coming back to you, Mr. Tiku, would you agree that like we have MPs and MLA courts, like we have, those fast-track courts, maybe we can have some kind of courts for the top judiciary also?
Right.
Yes, some special court for judges.
Mr. Tiwari, just a moment, please. With that view in mind, at least Delhi and other states, they have these specialized courts trying the cases relating to MP and MLAs.
Everywhere in
on
India.
a fast-track basis. But yes, there is no court as such trying the case against a judge. Because let us be honest, when the Constitution was made, no one ever thought that after about 75 years Constitution working, this will be the condition of the country. No one anticipated. Otherwise, judges were taken as nothing but a spirit of a god who could never go wrong. But then reality has shown us otherwise. Yes, to say that make a separate law for them, that MP, MLAs, judges, bureaucrats try, I am not too sure whether any superior court will accept, because you cannot place class among class. Offense is an offense. Committed
No, if
by
we can do it for the
individual
MPs who
or
are also
a judge,
honorable.
he is an accused.
If we can do for the
He's
MPs
entitled
and
to
MLAs
same
who are honorable,
visibilities
we can do it for
and
the
same
top judges
rights.
also, why not?
No, but I am not too sure whether the superior court will ever accept this. You are creating a classification that you being a judge, like Mr. Tiwari is suggesting, when judge is in trial, he is not on a trial as an individual. It is institution under trial. Perceptively, it may be
Both of you
reality,
agree on
yes.
that. I also agree on that. Kishore would not disagree with that, but still we are stuck. We are not finding a way out. I mean, we are already discussing the possibility of a comeback of the NJAC. None other than Vice President of the country has spoken about it, suggested about it. The government, of course, is letting discretion be better part of valor. The government is not openly saying anything till the time at least the probe ordered by the CJI is completed. But the fact of the matter is something has to give. Something has to happen.
Yes, Abhishek, let me make it clear for you. Let us not confuse. NJAC has nothing to do with the district judiciary. Let me make it very clear. These trials are never taken by the High Court or Supreme Court. These trials are only taken by the trial court who are an additional session judge or a session judge. For them, it's a case whether of a POXO, whether of a corruption, or whether of rape, murder, whatever it may be. NJAC doesn't come into picture there. NJAC comes when there's an appointment to a post of High Court judge. So let us not mix up the NJAC with the acquittal of, I don't know whether the judgment is right or wrong. Assuming what Mr. Tiwari is saying, there was evidence of having found 15 lakhs. Still the trial court has given the benefit of doubt. If it is wrong, then certainly CBI will file a leave to appeal. And it is not that unknown cases that acquittals are not converted into convictions. It has happened in Delhi.
Yeah. No, we are not holding anyone, we are not holding anyone guilty. The judge would have given this verdict based on whatever was presented to them by the prosecution and the other side, obviously. And the only contention here is, Mr. Tiwari, that the kind of delay, and you have also sort of suggested that maybe there was an element of delay injected into the process using technicalities of law.
Yes,
so
yes.
Can we do something about that at least?
Pardon, I fail to hear your question.
No, my question is that you also suggested that maybe an attempt was made in this case of injecting, technicalities of law to delay the process, of trial in the court. Something can be done about that at least.
Actually, I have not seen the judgment, so I am not aware as to on what counts the court has acquitted her. I am not sure, but if I invite your attention on one judgment of the Punjab High Court in Justice Nirmal Yadav's case. That petition was decided on 14th November 2011 when she challenged the sanction order and cognizance order under 482 petition before the High Court. In that case, in that very case, the High Court says that you are not above the law. You are not above the law. And High Court found the case fit for trial. That judgment was challenged by Nirmal Yadav in Supreme Court because procedure so says, procedure is there.
Yes.
She is having every right to challenge that judgment up to the last court. The last court decided that matter probably in 2014. You see, from 2008 to 2014, the case was at the stage of cognizance only.
Yes.
And therefore, when Supreme Court, and every time, every order, single order was challenged by Nirmal Yadav in various forums.
Yeah.
Then Supreme Court says that you are injecting artificial delay in this matter.
Yes.
You are using the technicalities of law.
Yes.
That is why I say that in the case of a judge, like on the similar manner, where Supreme Court has ordered for establishing a special court for MP MLAs, why only MP MLAs? Why not those persons who are treated as God by the society?
Yes.
It is the question, it is a question of faith.
No, my
My fight is only on one issue. My fight.
No,
to
I think we are still
interpretation and
getting stuck into
vital
technicalities, Mr. Tiwari. You know, my question is, and as Citizens' Voice, Kishore, you would agree that people want top judges of the country. And we are, as I mentioned, we are having this conversation in the backdrop of the Justice Verma debate. You know, people want more accountability. People really want to trust the judiciary and to be able to trust the judiciary, for which, you know, the episodes like Justice Verma and in the present instance, Justice Nirmal Yadav case, the verdict that has come today, sort of act as a dampener, Kishore.
Yeah. So, couple of things. First point is that when it comes to judicial things in India, delay is the norm. Fast tracking is a surprising element. It doesn't happen. It's an exception. So let's understand this. Common people have realized this long back. If we are going to tell lie in the media, we have to say that, you know, judicial actually works by. It's absolute. In my particular case, without going into the merits of the case, in 4.5 years, you would be surprised to know that I have visited the judicial forums 134 times, and out of which 84 adjournments. This is the classic case with which no judicial judge, whether it is a tribunal level, whether it is a high court level, nobody is accountable that this many number of times you can give an adjournment. As the famous dialogue in Sunny Deol's movie goes, that Tariq pe Tariq pe Tariq, it keeps on going on. How many times in independent
it can't apply to the top judges, Kishore. Unfortunately, that seems to be happening. I believe there are lessons. It's a warning shot in a way, insofar as the Justice Verma case is concerned.
Abhishek, just one final closing point. How many times in independent India have you seen top judges or bureaucrats behind the bars or convicted? It doesn't happen. And let's not, you know, hide behind facade. Corruption is existing in the system. Corruption is existing in every system. I'm not pointing fingers at individuals, but the system is corrupt. We know it. It has gone from our blood to our DNA. If we refuse to accept it, joke is on us.
I think if corruption is part of the DNA system, each one of us are to be blamed, including everyone on the panel, including me perhaps. And that's why I think we need to collectively appeal to our own conscience first and then to the societies and do something about it.